I have grave concerns about other privacy rights. We've never seen that kind of a scenario where it goes forward and then goes backward to a place of less progress, a place of fewer rights. It is highly uncommon to have the Supreme Court of the United States issue a ruling that overturns 50 years of a right existing, and that overturns precedent of the Supreme Court that had been reaffirmed over and over again as to its fundamental holding, where the overturning of that decision results in a contracting rather than an expansion of rights. We've certainly seen many examples through American history where the court overturns precedent, and that can be a very good thing. The most prominent of those, of course, is the overturning of Plessy v. Ferguson's sanctioning of so-called separate but equal. The idea of Plessy sanctioning segregation was a manifest injustice, and it took decades of concerted effort on the part of interest groups to get to the place where the court ultimately held in Brown v. Board of Education that separate was not in fact equal, and that required the integration of schools and the integration of many other facets of life. The Supreme Court had initially held that the state of New York lacked the power to regulate long working hours, brutal, unsafe working conditions, in some instances, child labor in bakeries. And you can make the argument that when Lochner said that that act, that legislation on the part of the state of New York was not allowed, that was a victory for the freedom of big business, in essence, to contract with employees who lacked any meaningful bargaining power. And so that was a victory in some senses for freedom of contract on the part of hugely powerful corporations against hugely powerless individuals. Approximately 30 years later, in a case called West Coast Hotel v. Parrish, the Supreme Court changed course. And this is part of reversing itself and ultimately coming around to FDR and the New Deal. And the court upheld a minimum wage provision in West Coast Hotel and abandoned this framework of Lochner. The rights that are being contracted in Lochner, when Lochner is reversed, are rights of powerful entities to extort and impose their will on powerless entities, primarily individual human beings. Dobbs' reversal of Roe is an entirely different matter. Dobbs' reversal of Roe takes a right that was embodied and codified, a human right, an individual right to privacy, a right for a woman to make a decision with her doctor without a political figure intervening in that decision process. And Dobbs undoes and contracts those freedoms of those women. The history books, I do not believe, years and decades from now, will be kind to the contraction of rights that the Supreme Court recognized, reaffirmed, and then suddenly reversed. I think that the assurances that the justices in the majority offer in the Dobbs decision are paper promises. They are the kinds of things that you say about issues that are not squarely presented before the court so that you can live to fight another day when those issues are squarely before the court. I have no faith that this court would not be willing to consider, and especially if somehow this supermajority that currently exists for the conservatives on the court were somehow to expand rather than contract, which could very easily happen. Imagine a scenario where Ron DeSantis gets 3 appointments to the Supreme Court starting in 2024. These are not far-fetched at this point, and in those scenarios, we could be lamenting and longing for the salad days of 2022 when this was the only privacy right that had been rolled back. I don't think it's hyperbole. I don't think that it is Chicken Little sky is falling rhetoric to say that there are real concerns about what this court will do prospectively because it can.